All right, everybody, welcome to the first live edition of the Counsel Table podcast. Hey, thanks, guys. Today, our guest is the best mediators in town, Chris Volf. Chris.
Thank you for having me, Tommy.
That's right.
Hey, yeah, thank you. I can't see you, but I think it's Adkins. I can see a shine.
All right, start with this. For the listeners, our goal is to have multiple generational lawyer listeners, young kids or new graduates from law school that are young lawyers that don't understand everything from a mediation standpoint. They get hauled there by their boss, or they write a mediation statement, don't have a clue about it, all the way to the big dogs. So that's our kind of intended audience. But people that don't know you, tell us about you and then tell us about what you do.
Okay, my name's Chris Volf. I tell people it's like the game of golf with a V. I have my beautiful wife back there who gave me Jill.
And your beautiful sister.
And my sister is with me. I got two awesome boys that are home, hopefully asleep, which they're not. And I got a lot of instructions tonight, not to cross my legs. You
can cross your legs.
You know.
Come on, Will.
Hey, she's not up here.
I can't do that without hurting. But anyhow, no, I've been I was 22 and a half years. I was with the same firm mostly. The lawyers here would know me from the defense side. Did a lot of commercial trucking defense work, oil and gas, personal injury, death defense work against most everybody that I can see. Out here 4.5 years ago, decided to go out on my own, kind of as a three-headed monster, doing oil and gas consulting work, kept some of my self-insured clients, and then started mediating. And within about 6 months, it took off from there, and all I do is mediate now.
Did some plaintiffs work too?
Did plaintiff work.
You can say the firm. Who were you at?
Johansson and Fairless.
Okay.
So Mike Johansson and I did most of the plaintiff work when we had the capacity to take on plaintiff work. But most of my docket on both sides have been large loss exposure cases, both when I did plaintiff cases and then, of course, on the defense side.
And the personal story is a fair one. So at some point you had an epiphany and said, I need something different. I love my partners. I'm leaving. And Jill said, you're a dumbass, man. I like getting paid every other month. Draws are one thing and tax man's something else, but at least I can know some money's coming in. And you said, to hell with it. I'm going to open my own shop. Yeah. Why?
I'll get to that in a minute. But Will saying that, I remember where I was in George West, Texas, hunting with my boys when Will texted me on a Saturday. He said, hey, when you went out on your own, did you ever think about doing plaintiff work? I was like, getting that text from Will, I was like, okay.
Yeah. Guess who was
I'll call you when I get out of the deer blind. So, and then he went off on his trajectory. Yeah. Now, I can say this. When I left to go out on my own, my oldest son, or really both my boys, they asked me two questions. They said, one, are we going to have to sell the house? And I said, well, I'll get back to you in about 6 months on that. And then the second question I got is, are we still going to be able to hunt at Todd Taylor's ranch? And I was like, well, I think we'll be able to do that too. So, it's been a blessing for me working for, great lawyers on both sides of the bar, having the support of my family. It just felt like it was the right time, to make that transition.
And and I remember this, with Chris and I had cases together where he had a lot of oil and gas clients that were really good. And there's a lot of heavy contract work and MSAs and indemnities. And it's not run-of-the-mill blood and gut stuff. It's got some complexity to it. You have to understand insurance. You have to understand commercial practices. So when you left to go, I'm going to do this boutique law firm, and I'm going to be a casualty lawyer and try some cases, and I'll help on the business side. But what was the light switch to say, to hell with that, I'm just going to mediate?
Well, like I said, I don't think I went in with all I'm going to do is mediate. I went in as a three-headed monster, and within 6 months, I got to the point with just my background and experience that my capacity to take on lawsuits and really, like, right now I'm working on one MSA, and I'm doing that as a favor.
You got busy because the phone was ringing and said Chris Volf's mediate.
Right. Will just wants you to say the same thing he did.
No.
Insurance adjusters were mean. They cut your bills. No. You left.
The second part's true. They did cut bills. Yeah. First part, I disagree with. Now, a lot of great insurance people. I mean, look, I will say this. Anybody who's done defense work, I know Strike, you did. Mike Strike did. Of course, Will did. I think guys that have been on both sides of the fence, it helps them be better plaintiff lawyers for sure. So, and you can see that with Will. I've seen that with Strike, other guys that I know that have done both sides. So having litigated on both sides, in my case, I think it helps me really be able to help both sides of the bar, effectively negotiate settlements.
What are you booking out to now? Today is what, January 21st? What are you booking out to?
So I actually just emailed you about 5 minutes ago for June 24th.
I got that.
Please hold it.
I think I got that.
You booking out till May?
No, I've got 2 half days in May and booking in June.
Okay.
Unless somebody cancels.
And
my wife almost divorced me last week because I did 3 evening mediations starting at 5:30, and which those are hit or miss. Those went till 10:30 at night, 3 nights in a row.
Yeah, and Saturday mediation, sadly, from time to time.
I've done Saturday. Too. I've only ever done Alton Todd, if y'all know Alton, great lawyer.
Oh, yeah.
I did one Sunday for Alton. I'm not sure exactly how that happened, but it's
it's hard to say no to Alton.
Hard to say no to Alton.
Well, it says a lot about you. You don't market because you don't need to market. Everybody knows you. You're hard to get into. But as a data set of how good your mediator, the first thing you ask is how far are they booking out? And if you're in June and it's January, that says a hell of a lot about people's need to have one of the best.
No, I'm blessed. It's a blessing. At the same time, I hate when good lawyers on both sides call me. I'm like, evenings, weekends, or June. All right. So I don't know how to fix that problem. So I would say this, if you have, for the guys that handle I handle all personal lines and commercial lines, but if you have a big multi-party commercial lines case, call me, book it June 24th. And if you cancel, 4.5 years, I'll have 0 cancellation fees I've ever charged anybody. There's a few people who are getting close.
Jill, are you going to change that policy?
There's a few firms that are teetering on, hey, you may get a cancellation.
We just talked about your Sunday rate's now 25 today.
25? Okay.
1,000 or 100? Someone will pay it in gift cards.
It's not football. Well, football season's over. Sundays are good now.
You'll give up a football game for 25K.
Well, so that's a lesson that you're offering, and I think a good lesson is, one, if you have a case, you know it comes in. If you're a plaintiff's lawyer, you hope it's a good case. If you're a defense lawyer, you can see it's a bad case. That's the descriptors.
Right.
And at some point is get on the phone with your adversary and say, hey, look, let's get on Chris Volf's calendar in 6 months, 7 months, because we're going to need that date. But what caution would you offer the practitioner on mediating too early? And what do you need to mediate a case? That's one of the big, multi-party explosion, something blew up, something's bad. It's not, or a bad truck wreck even, not a, car wreck case, but something that is, man, if it's got to make sense, because the decision makers aren't the lawyer and they're not the primary insurer. It's vertical claims and chief claims officers on multiple insurers oftentimes.
Right.
And they need data. So what was your recommendation to be, say, man, don't come waste our time or waste your client's time or waste your client's money unless you're ready. What's it mean to be ready in a big case?
Yeah, on a big case, I think, back up for me as a mediator, it's before you show up. First of all, it will help me on big cases if I can get reports and expert reports and other things y'all think is important more than the night before, or more than the morning of. Not very helpful for me to get it then, because I will read it. Atkins knows, Strike knows, I'll read stuff to help you and really to help the defendants if they send me enough stuff so I can go talk in your room. But if I don't get it far enough in advance, I can't do anything. But as far as early mediations versus being prepared for your mediation, if you back up, there are some cases. I mediated one, trying to think who the plaintiff lawyer was, but they didn't have a lawyer. It was a commercial trucking case, $1 million policy. I think it was Progressive. The adjuster who had worked with me before, she showed up without a lawyer, pre-suit, got the case settled.
That's because she knew you.
Well, and she knew that case was a little bit easier. It was in a pretty small strike zone that everybody agreed probably the ultimate value was, so it was easier. But a lot of times the pre-lit stuff is difficult. I mediated a case that was not pre-litigation recently that both sides were not, respectfully, good lawyers on both sides were not prepared. Plaintiff lawyers had no clue of the tower insurance, 0 clue.
Not our firm, right?
Yeah, not any of the firms here. Didn't, some of it was not because they weren't good lawyers, they didn't ask. I think you were saying get out ahead of that, and they weren't asking those questions on the front end to either ask for excess policies or, for example, they told me there was $6 million in coverage, 2 defendants. They thought one had $1 million policy with a 5X, and then the other had $1 million policy. They were wrong. It was the primary policy was $1 million policy for both defendants. It was just the co-defendant was a property management company. It was just a named insured under the same policy. So there really was only $6 million worth of coverage for those. But guess what? There was a whole lot more excess they didn't know about. So that was the plaintiff lawyer's problem on that case. Death case, 2 firms representing different wrongful death beneficiaries, so they needed to be negotiating jointly to put pressure on the defendants. And the problem with the defendant is he came in with a defense on a death case that the guy who died was dead before the allegation of why he was dead in the lawsuit, which is a pretty big, important defense. And we hadn't exchanged expert reports. And so the plaintiff lawyers didn't even have the ability to test that theory. So I was getting nowhere on a big case like that without that groundwork having been laid on the front end.
But you know what's good about that is that then you get time to work on some other cases, like follow up with me after a short all-day mediation.
Every time.
Yeah, I got a call shortly after that one. That was nice.
But I mean, look, I think on the plaintiff side, you got to get on the commercial lines cases, you need to get the insurance tower in order. And it's not
the policies
always
of insurance and not just the deck page and read the whole policy. Get the contract, make sure there's no AI or CI where there's more insurance than you think there is. How's that?
And look, unless the law's changed, I don't think that there's a law that says me as a defense lawyer gets to pick what policies I want to present, right?
No, you're supposed to get
yeah. It's a little different.
Well, I'll tell you what I would do on my oil and gas cases where I'd have $100 million towers. Case probably nowhere, at least back then, that was a pipe dream, right? Not anymore, maybe, but I would just put will supplement. And wait for Strike to threaten to take me down in front of the judge, and then
they're still
produce
doing
them.
that.
Yeah, I mean, well, that's okay. But not producing them or you not pushing to get to make sure that there's not any more insurances starts you off behind, and you don't even know where to put pressure points.
Yeah. On that note, how are you dealing with a plaintiff's lawyer who is completely undervaluing your case?
Well, their cases usually settle.
Well, be kind enough to tell them, hey, look, if I come in and you think I'm undervaluing a case, have the courage to say,
That's what I
Mr.
call
Moore,
an easy day at the office.
you missed the boat, sir.
No,
Is there a thirst by the insurance industry to have a early mediation because they think they can get something done that they can't get done? Or is it this is a junior high dance and we're going to stare at each other across the gym and not really do anything?
Going back, just kind of circling back to one of the things you said, we know as lawyers, like I would have some insurance carriers like, hey, we can't mediate until we have our expert review the records. And for me, it was okay, I know what my experts are going to say. I've read enough medical records. I don't need it, but sometimes they do. And so you got to be mindful, of what they need to get their case evaluated. And then you got to give them time too. It doesn't help you. I will say this. I don't know if either one of you guys agree or disagree, but it helps, I think, as a plaintiff lawyer to send a demand before you show up at mediation.
Oh, that is a policy that we have, because then you show up and then you're coming up with numbers and then they think this number comes out of thin air. But at least if they have it, we try to do 21 days in advance. Are you good with that? I mean, and then we use that as our mediation statement.
Yeah, I mean, 21 days is better than none. I don't know if you handle large loss cases.
I would give more than that.
Yeah, if you can.
I mean, we try to do 30 at top. There's
a lot of former defense lawyers in here. I would say that, again, this is specific to large loss commercial lines cases. I would get a demand out, if I can, at least 60 days, sometimes 90 days, if you can stomach it, if your case is right for it, because most insurance companies, they need a pre-mediation report on 7-8 figure cases. They need them at least, they're roundtabling those 60 or 90 days before you show up and mediate. And if they're left to guess, or they come in thinking, oh, he's going to demand $5 million, and you show up and demand $25 million, we're already heading in the wrong direction.
For the practitioner, how it works. So if there's an excess tower, multiple layers of excess, the defense lawyer is going to write a report for the form used by the primary insurer. The excess is going to have their own lawyers kind of monitor the case and give their 2 cents, but that one report's going to ride the reserve recommendation up. And it takes multiple meetings to be able to get it right. And there are, as you said, roundtable. That's literally a meeting where everybody gets together. Maybe the chief claims officer or the vertical supervisor or the lit director's not available for 45 days. And it'll get calendar then. If your mediation's after that, tough shit, you're not getting the authority on it. It's just what's going to happen. So for big cases, the practice point would be get a credible demand out as quick as you can that gives the lawyer a chance, your adversary, a chance to write a report that's reflective of the risk, because it's got to go up. And then there's going to be multiple people look at it, both on the excess side and the excess lawyer side. And without time, it just can't happen.
But how often are you seeing that the first mediation is a stepping stone? I mean, I feel like now big cases like that take 2 to 3 mediations
They can.
minimum.
They can, just based on the nature of the money we're talking about. This guy, yeah, he and I had this phone call. LinkedIn. If you like LinkedIn, go look at Strike and Greenberg. They're very good at it. But I think that one of their questionnaires was, mediation is a waste on the first one. Nobody's trying to show up and settle. And I disagree. That's not just mediator talk. If you show up prepared, I disagree because
Greenberg post.
it was Greenberg. Sorry, Strike. That's a Matt post. But all kidding aside, I understand the frustration sometimes when the mediations don't go as expected, or you feel like you don't make a lot of progress. But if you mediate like me, I promise you it's a productive day, because even for the insurance company, even if we're end up miles apart on the defense side, there's lawyers are carrying 100 plus cases in their load. Insurance adjusters are carrying more than that. And if nothing else, you're requiring everybody to sit there and focus on this case, this day, and you learn stuff. I mean, even sometimes you learn your medical numbers are off. Mr. Smith went, had another doctor's appointment we didn't know about. So it's still a good opportunity to get people to focus now.
And as a practice,
and
go ahead.
Go ahead. Now, another question that comes up a lot. I mean, we used to do openings all the time, right? That was where you flexed your muscles and everybody, your mom, but they're not there. It's not as common anymore, but I do think there's still benefit. Again, on a personalized case where we're fighting over 30 grand, I don't know that an opening is really going to help you that much unless there's just something critical in the case. But on the bigger cases, 110%. I think sometimes, how many times Will or any other defense lawyer where you take a deposition or your client gets deposed and just does terrible, I can put in a report, Andy McCluggage got deposed. He was terrible as expected, blah, blah, blah. You can put that, sorry, but you can put that in a report all day long, but sometimes it doesn't bring to life exactly how bad it was. I had an oil and gas case, wasn't even my witness, but it was a company man, Tampa, Florida. My wife was with me, but not at the deposition. She was at the bar because me and Paula Wyatt fought till 10 o'clock at night on a deposition. Top 5 worst witness in 26 years of practicing law. I, as a defense lawyer, sent video clips to the insurance company to go, I can't do justice as to how bad this guy was, and sent it. So sometimes, like you mentioned Moses, he'll do a lot of them. And I think it benefits putting some of those clips in front of the defense side. Andy?
Yeah, there's 2 things. Let me say 2 things. One, Andy said put videos in demands, right?
It was a Mo case that I had, and I wrote a report as a defense lawyer about how bad this guy was, because Mo asked him about how he was getting speeding tickets. He said, you get a speeding ticket and then you change your behavior and then you don't, you speed again. Why do you do that? And he said, because I wear steel-toed boots. And Mo said, you got a heavy foot? And he's like, well, guess so. And I wrote that up to a defense lawyer, and then we mediated the case. Mo put the video clips in the opening, and the adjuster turned to me during the opening session and said, you wrote this in a report. I didn't understand how bad it was until she saw it. And that's exactly what it was.
2 practice points, some mediating, and Moses. So if you don't want to do a opening, that's fine. Mo does them all the time, and they are detailed and they're impressive. And I know some defense lawyers would be like, well, I don't give a shit about your case because they want a tough guy. I was like, no, dude, I want to see it because I want to see your opening and I want to see what I've missed. From a practice standpoint, with mediating with Mo, it's not his show, but I'm going to say it as a credit to him, and mediating with you is, one, you better be ready and you better have told your client the case, because Mo's going to be thorough. And if they're for the first time hearing it, that ain't good for you. And when Chris Volf walks in your room and says, by the way, this case is set for trial in front of Judge Smith out in Square County, West Texas, and do you know this? And he'll know what cattle brand he uses, and you're sitting there in front of your client not having a damn clue about your own case, and Chris knows more than you know, better learn your case if you're going to mediate with Volf.
Preach, brother, preach.
The other thing I wanted to say is...
And Square County, West Texas is not a real county. I said the other day and somebody looked it up. I'm like, no, it's a metaphor for Square County, West Texas.
But the other thing that I wanted to say is, Will, you can hold your own microphone. Don't make it
Tommy's show. This is great. It's Tommy's show. You can pull it back.
This ain't Thompson Co. anymore.
Yeah.
All right. It's
I'll hold his microphone anytime.
He's like about to be sent back there.
No, but one more question about, when I started, I guess, mediating with you when you became a mediator, it was, one of the first cases was a motorcycle fire case, you might remember. It was probably your worst nightmare.
I do remember.
I was taken aback by your approach to mediation. Was you asked hard questions, probing questions, detailed in the file. I guess I was asking, my question is, do you find that to be important and helpful to push and probe? Because frankly, you do it, and this is not, a advertisement for you, but you do it more than a lot of mediators do that have become more number runners. But just take us through your process of probing both sides.
I do both sides.
Yeah.
I don't apologize for it, but there are times where I'll start asking questions. A lot of it's to educate me, to help you in the other
Can
room.
we generate a system where if I blink twice, I don't know the freaking answer?
That's all. Sometimes I'll ask questions, and then I'll, it doesn't matter which side
you
it
can
is.
text the same question,
Yeah. Well, I do try to get cell phones in case I need to ask. Hey, they're saying you didn't designate experts. Is that right? But when it comes to stuff like that, I ask questions sometimes and people don't know, and it's not me trying to embarrass people because I was a trial lawyer and I know you got 500 balls in there and it's hard to focus and remember every fact, whereas I just read it the night before, the morning before. But it's for everybody's benefit, and it helps me kind of zero in on where I think this case based on these facts. We all like to talk about generalities, but on this case is what's important, right? So I don't know, Strike, you had a question?
Well, yeah, I mean, we did it, right? I mean, as an insurance defense lawyer, you want to keep your clients, the insurance carriers, so you write your reports. You don't want to fall on the sword too often, and so sometimes you don't talk about how bad the clients did or how bad the facts are. What can we do as plaintiffs lawyers in the demand, either earlier, the different types, the way we demand, either producing documents earlier, what can we do to get the carrier to know, hey, this may not exactly be the way it's getting reported to? Because I know that as an excess lawyer, I saw a bunch of reports from defense counsel, and then I saw the facts, and it was not, there was a little gilded lily there as far as was a lot worse than what I got reported to. So what as plaintiffs lawyers can we do to really tell the carrier or someone making the decisions that, hey, look beyond the reports you're getting, here's what's actually going on. What do we do better before mediation?
Yeah, are you wanting to say something more?
I was texting Todd as I show in at Exxon. To answer his question.
Okay. Yeah, I wasn't sure if you were going to interrupt him or not. Yeah. But
I might now.
now, look, timing's important, right? When you get the demand out is important. But when I did handle the plaintiff cases that I handled, which again was probably 10% or 15% to 85% defense, you would never get a Stowers demand from me as a defense lawyer that didn't have the kitchen sink. Even if, every medical record, every bill, I wouldn't, unless there was a compelling reason to rush out a demand, I'd have everything. So they had almost no excuse to say, other than if you were going to do it before deposition, well, we need to depose the person before the but I tried to give them every record, every billing record. Of course, I didn't even fight the prior records. Here they are, right, within reason. But timing, I think, Will, you would agree, timing is important, even not just for mediation, but before trial. I've had guys show up, trying to think without saying the case. I had both firms, it settled a week and a half into trial. I mediated it, say, 9 months before trial. And let's say the case was worth, settlement value was probably, using fake numbers, $5 to $10. Plaintiff lawyers showed up. They finished mediation at $20. They were 2 times the realistic high-end strike zone of that case. The self-insured big defendant, they said, okay, we'll fight fire with fire. We're going to offer $2.50, half down the low-end value of that case. No pressure. There was zero pressure. My phone started blowing up a week and a half before trial. Plaintiff lawyer, how you think you can get them to take $15? I'm like, I might have had a conversation with them if you'd have done that at mediation. And then the defense lawyers call me unbeknownst saying the same thing. Hey, you think you can get them to take $5, which was the low end of the strike zone? Maybe. If you'd have come with that money at mediation, a week and a half into trial, guess where that case settled? Between $5 and $10. Right. And the hard part for the plaintiff lawyer is like, things can change in trial, right, if it goes way sideways. But again, just like we were talking about 60 days, 90 days before mediation, you're definitely getting trial authority. I've had cases. I've been in trial. I can remember it like yesterday, Beaumont in Jefferson County got a good result, but the pretrial hearing, we never even got to talk. They got I could tell a whole podcast on that trial, but we got a day of nothing but plaintiff pretrial, everything they wanted came back. That night we go to the hotel room, plaintiff lawyer calls and he says, "You boys ready to settle?" And we were like, "Yeah, we kind of would like to." After that and I wasn't naive to that, what was going to happen. But by then the ship had sailed. People were making decisions that I didn't even know at an insurance company I'd been doing work for 20 years. And their message was, "We'll pay a penny more than our last offer when the last appeal is denied." And it was like, okay,
There you go.
made my job easy. Just head down, try the case. But more money could have been had they not waited that long to get semi-serious.
So if you haven't mediated with Chris, this is what he does. He wears your ass down. He will talk to your client, but he's approachable, makes it easy, makes talking about settlement inclusive. So, I mean, I enjoy it, but it's hard. You know, he tells you, get to that $10 faster, and all of us fight you. You know, we fight you.
You should.
And so you build a rapport for trust, but how do you get there? How do you get us to not do the matching game? How do you get us to give you, hey, this is an area we want to be in without losing confidence that we're going to give up negotiating power?
Yeah, I'm going to tell a quick war story. I ordered a beer, by the way, and they gave me a 40 ounce.
Do you need another one? I'm going to go I'm going to walk up and get a cocktail. Do you need one?
No.
I have one, yeah.
What is it?
Those Stella.
Omar win the Masters.
Yeah, exactly.
2026 coming up.
But Chris Atkins, he and Claire Schindler had an evening mediation with me. It started at 5:30, and usually my hope is people will work a little more efficiently on the evening mediations. That does not always happen. My record is 1:29 in the morning. 10 o'clock, maybe twice last week.
Can you institute a punitive billing policy after 11 p.m.?
I may have to.
Yeah.
So we have this. It was go to Omar, me twisting people's arm. I was not twisting anybody's arm, but I talked to the plaintiff. Her name was Miss Smith. I gave her my long-winded spiel that most of the lawyers' ears bleed over. Went and got the first offer. I don't remember what it was from the defendant. The first offer of the night. It was $300,000. Let's say. And by then I'd already, emptied the tank and all my good BS to the plaintiff herself. So I talked to Claire and tell her, hey, they're offering $300,000. We talked a little bit about the case, and I turned to the plaintiff out of respect for her. It's her case. I said, Miss Smith, you got any questions? She goes, no, honey, Chris, but I'll take it. I'll take it. Anyhow, she got paid a lot more than that, but it was tempting. Good thing you are nice to me, but I'll take it.
How do you handle the concept of, because I was a baby lawyer, it was Bob Black. First mediation I ever had was Bob Black. Left my wallet in Beaumont. I was meeting with him in Houston. He had to pay my parking to get out of his Allen Center garage. I'll never forget it. But he kept saying, don't worry about the other rooms doing. Don't worry about the other rooms doing. And I was a little kid, so I listened to him. But now I'm still concerned about, well, how do I maintain credibility if I'm like, don't know what the other room's doing? Well, I'm going to keep going and keep going. If these assholes aren't going to do anything commensurate with that, how am I going to maintain the credibility of the case value when I'm acting the right way, I think, in the settlement narrative, but they're not? As a plaintiff's lawyer, not a former defense lawyer.
Yeah, I mean,
Thanks. Don Moy's in the house.
Yeah, what Omar...
Yeah, you don't hold your own mic. You don't hold your own booth.
It's the Will Boy show.
I've got some free advice from him.
I just checked on Google. Omar's never won a Masters.
VJ Singh was my other name. I go by VJ Singh when I play golf.
That's pretty funny.
You won two.
No comment. What was the question?
Well, yeah, what happened?
Trying to move it without getting caught up in some ritualistic dollar crap and just saying, you know what? I'm going to put as a defense lawyer, put your money up or shut up.
Yeah.
The plaintiff's lawyer, be credible on your moves.
I preach, don't be reactive. It's easier said than done. I'm not writing checks, don't have my hand out for money, but I do believe, this is not a joke. I have 20 rules of mediation. I could recite 0 of them. I think they're cut and paste. I send them to everybody. I hope y'all read them. They're important. But
supposed to sign it and send it back?
Yeah, no, I don't.
You mean this a W-9
Well,
is all
you
you
do
care
actually
about?
sign to say you read them and you're going to follow them. I don't even know what they are. Just sign it. But Rule 21, I've been telling people I'm about to add Rule 21. If you say the word, unless it's a $30,000 car wreck case, if you say the word midpoint, I'm putting you in timeout for a half hour. Has nothing to do with the merits of the case and causes more. You'd be surprised how many mediations that fake philosophy has in causing cases not to settle. Hang on, Chris. And then the Rule 20.
Spin that out. Why? Because there's some people who are going to watch and they're going to go, I'm a bracket guy, midpoint, a midpoint, a midpoint. Tell us why.
Well, yeah, bracket's a whole nother topic. But what I tell plaintiff lawyers is, look, as long as you're at or above your want number, which you're not going to get at mediation, you're going to take a little bit less than what you want or go try your case. They're going to have to pay more than they want to go try their case. But as long as you're at or above your want number, you hadn't lost anything. Even if you stick around at some point, right? And I'll tell you when I think we're wasting time. But at some point, you get, as long as you're at or above your want number, stick around, find out what they brought for your client's sake. And then sometimes you'll find out it's not as far apart as you thought. That can be cured in other ways, proposals, other things. But and then Rule 22, don't match. A very good plaintiff lawyer on a big commercial case, doesn't matter where he started, they offer $100,000. He came down $100,000 on the first offer. A lot of lawyers like that. I promise you, when you do that, because he told me, because I thought they'd appreciate me matching. I'm like, no, when you match within the first 3 moves of mediation,
the midpoint at that point.
you're sending me in there to give them the middle finger, and you can come do that yourself. Is the way.
A little less, a little more.
What do you do?
And if you're offended by their first move, just don't match them. If they come up 100 and you're really mad about it, Angel, don't just go to 75, because you're at that. If you go to 100, they think you're here, which they already come in thinking you're here doing just to jack around and play games and see what if you can raise the floor, right? That's what they're meant on the defense side. Just like Greenberg thinks they're just coming to mess around. That's what they think on y'all's side. And so don't prove them right is my point. So, but midpoints, the problem with midpoints is literally has nothing to do with the merits of the case. And I tell a lot of you guys, I'm not naive to the fact that, especially on the insurance side, they sometimes will pay attention to that. Again, more on personal lines cases than commercial lines. But if you start not liking the midpoint, even though I preach against it in the beginning, it's real easy to fix as a plaintiff lawyer or defendant. Throw out your own bracket, create your own midpoint of where you want to be. And I hate, by the way, had an adjuster this week who's not a bracket guy. I like brackets, which we can get into, but he got worried about midpoints and midpoints. I don't care about the midpoint of your number versus their numbers. Now, I do care about a midpoint of your bracket. Don't lose sight of that, because they're going to assume you would take it, or in the other case, pay it. But anyhow, does that answer the question?
No, it does.
We talk about hole 16 when.
Oh my God.
And he had a 2-stroke lead.
Anyway, thank you, Jill.
I like it.
Yeah. Ask your question.
Hey, so how are you dealing with?
You can't ask your own question.
Ask your own question. Yeah, he's texting me.
I can interrupt everything, but I won't ask the whole question.
And Exxon now. Exxon's only been a few weeks.
It was a 7-iron.
I mean, I assume you're hearing that shit, right?
Yeah, I mean, as y'all probably know on the defense side, probably 9 out of 10 cases I mediate on the commercial side, right close bargain. They're either present at my in-person mediations or involved and the insurance companies are smart, right? They're getting the appellate counsel out early, whereas you used to just bring them on, a week before trial. Now they're getting them out early, and with that line of case law, talking about sustainable verdict, because they're not going to argue that you can't go get $100 million verdict, because there's a bunch of examples, but how do you sustain it? So that's something else.
How do you sustain it?
How are you doing it?
That's where I need y'all's help. Like, give me, you got to walk through that line of case law.
AJ, sustain our verdicts, AJ.
Yeah.
That's the goal.
Yeah, well,
Yeah, but
I
you
can tell you
gotta
what I'm doing
yeah.
is one, the days of non-suiting your past medical, that's gone.
Yep.
The days of not generating a meaningful economic model on wages and vocational disability, that's gone. The days of not paying attention to physical pain as an element of a line and a separate line needs to be made more attention to. Because what happened at Exxon? They flipped mental anguish. They didn't really touch some of the other stuff. And, Chohan is a mental anguish death claim. It's a mental anguish claim. And it's sad, but it is take more time with your clients on the stand and make sure you can prove nature, duration, severity, beat the hell out of parkway factors into their brain about the daily effect of their day or the effect on their daily lives, and have to support it with experts to come talk about PTSD elements, loss of life elements, grief elements. And you put, for example, I won't name names because she does both sides, but there's some very skilled clinical health professionals on the consultant side. If you don't, and I'll say this as indictment of the plaintiff's bar, don't try to masquerade them a treating lawyer or a treating physician. Screw it. Make them a retained, own it, and go, let's talk in front of the jury. I paid you to be here. We need some guidance. Let's talk about it. And if you develop that mental anguish model, it's a huge help of keeping it.
But is it easier to drop mental anguish now as a line item? And
I have a verdict. We have a verdict on appeal now, and I'm not blowing any confidences. We got to talk about. We can keep it on an unchallenged economic line because it's unchallenged. We can keep it on a physical pain line. Do we go get flipped on this mental anguish deal? AJ, what happens? Does it all come back, or can I say to hell with it? We'll just withdraw the mental anguish. What are you going to do now?
You mean on appeal?
Yeah.
They can reverse and remand saying it's legally insufficient.
And the whole thing comes, except what they challenge, except the elements they challenge, right?
Right.
Yeah.
Like no remediature, no retry the case. It's gone.
Yeah. So I will say that Chohan came out, it affected every mediation you had because it was, and then we're like, hey, it's per curiam, it's a death claim, blah, blah, blah. And then now we can do, per diem arguments, I guess, because Tracy Christopher says we can. Justice Christopher, who wrote a recent opinion, lovely jurist, but an opinion that is difficult to get around when there's a phrase used, ordinary car wreck, meaning someone's in an ordinary car wreck somehow is not injured as much as someone that's in a chemical explosion, which is unfortunate because if one's, neck herniation ruptures and they have to get surgery and they have to deal with the contentions associated with that recovery, it shouldn't matter if it's a minor car wreck or not. It should matter what the pathology of the injury was and how it was addressed medically. But yeah, it is because you're right. And I'll say to credit Jessica Barger's firm and Tom Wright's firm and Howard Close's firm and Judge Guzman's firm, they are incredibly skilled. They're very good at it. On a blood and gut side, on the casualty, there's nobody better at it. And as the plaintiff's bar needs to be mindful of, you better be ready and you need to hire the AJs of the world to come and help us because you're going to lose your case if you don't.
Yeah, so that's the key, right? From a mediation perspective, give me the ammunition because you know those details. I don't always, unless you give me the expert report, so that I can try to go toe to toe with the appellate counsel.
Is it resonating in that room though that it's still scary? I mean, you're still settling 8-figure cases. I'm sure you're still settling stuff well above that $20 million, $30 million mark where they say that's never going to be upheld, right?
Yeah, there's still a lot of 8-figure settlements for sure.
There's one trick
every case is.
One trick I'll offer is be mindful of if they made an appearance, this very skilled firm, they're friends of mine, I'm very good friends with them. If they make an appearance as defense counsel, what are they then? They've got Tilly obligations to the policyholder because the policyholder is their client. If you can put a Stour situation into that room and make that client scared of that case, then at some point that lawyer needs to be mindful of what that client wants, and that client wants that case settled. They need to dial back some of that nonsense, and the mediation with you is the perfect time to do it because it's what does the client wants this case settled. So if they're raising hell about appeal, we're going to flip it. If the client wants to settle, the client wants this case settled, and the lawyer needs to pay attention to that. And you can put those lawyers in a box when it comes to their ethical obligation.
Hey, Will, where's the pressure point on money on that? I mean, if somebody has $100 million coverage, they don't give a shit what the client says.
They don't. Well, it depends. It absolutely depends. Depends on if they're in renewal, it absolutely matters because the underwriters who aren't supposed to do anything on the claim side are knocking on the claims door saying, get this case settled because I want to renew this business and I'm getting points on it as an underwriter, as comp as an underwriter. The broker is absolutely going to be motivated because even if they're not going to get renewed with that insurer, they still need a broker to go to the open market and go get either a wholesale broker or a retail broker are going to go get them insurance. So they're going to be motivated to sell that case because they are a claims advocate for them. So the plaintiff's bar needs to pay attention to the broker is our friend in resolving cases.
How do they know that?
You can pull the paper and you look who the broker is and send your demand, put a sentence that says, I'll waive 408. I'm going to send this to the broker. And I send my demands to the broker.
That's actually some advice Will gave me this past week. I didn't do it because I didn't know who the broker was and I didn't feel like looking through an insurance policy. But, it got people talking when you send. Will helps with the pressure points and the insurance policy, you got to pay attention to the stacking.
Have to. Before
It's
we get done,
important.
we've only got like 8 minutes. You got to share with us mistakes the plaintiff's bar makes and defense bar makes that are almost ritualistic nonsense you see all the time that we shouldn't do. For example, I mediate tomorrow, not with you. Probably won't get my case settled as a result. I got my summary judgment filed tonight because that was going to happen. The night before mediation, I got the no evidence traditional summary judgment on a Timberwalk case because that's agreed. But that's a defense ritual. Hey, look what I did. I filed a summary judgment before mediation. Silly stuff. What kind of bothers that we can all learn from of stop doing because someone told you to do it or your boss did it?
I mean, those type of things aren't going to be helpful. As a plaintiff lawyer, drop a new medical on them. Now, I'm not even just talking about the day of, a week before, 2 weeks. I mean, going back to what we were talking about, they're getting their ducks in a row 60, 90 days before. If you're dropping substantial, it's one thing if you're, hey, a couple more chiropractic sessions, but if you're going to drop life care plan or, hey, a surgery bill or something, you're done. For the kind of money you're going to be asking for, you're not going to allow them to be in a position to evaluate it. Now, we can still negotiate the case, give me a chance to talk to the other side, to your client, but we're not going to get the case settled unless it was a fake supplementation. So that's probably the biggest thing. And then going back to what I said earlier, and I mean this, the reactive negotiations, again, y'all have heard it. I'll talk to your clients whether y'all want me to or not, but what I tell y'all, as long as you're at or above your want number, don't worry about midpoints, floors, ceilings, and check. We all have egos. Check your ego at the front door. I tell defendants, y'all aren't ever in there. Some of y'all are. I'll tell the adjusters, look, how do you combat the unpredictability of Harris County, Texas as a whole, but Harris County? Hey, you got to hire good lawyers, which doesn't always happen, but I'll tell them.
Kirker Garcia.
Well, I'm talking on the defense side.
Well, he says this line every time. You got the best lawyers in Texas. I'm like, how many people you tell that to?
Yeah, one a day. Yeah.
I believed it for the first 5 times.
Some of them I believe it, but no, I tell them, look, you got to hire a great lawyer. On the defense side, put your collective years of experience together. Because despite popular opinion, you would even agree. Now that you're on this side, there are a lot of insurance adjusters that are smarter than us.
There are excess adjusters. So the badge of these evil empires of sitting behind a cubicle, excess guys get it, and they've got a job to do. But yeah, that you can walk the hallways with an excess adjuster at your office and get with you and have a face-to-face, get the defense lawyer out of the way, get the insurer involved with your consultation, and get a case settled. Have the courage to do it. And then I want to talk Zoom versus live at some point, so don't forget that.
Yeah, so the name of the game, you said pressure. The name of the game is pressure points, and that's at mediation too. If you start high, stay high, you're not putting any pressure on them. What I tell defendants is if you've internally evaluate your case at $10, unless you're pre-litigation or pre-discovery against the kind of lawyers that we're talking to today, do not leave my mediation without putting at least 8 of your proverbial $10 on the table, because the biggest mistake they make, and at least one firm in here benefited from that, is they fight fire or fire. Oh, you're going to start high, stay high. We're sick of this. We're going to start low, stay low. Okay. Your case is not going to settle. And then you're going to go try your case, both sides. I've had lawyers go try it respectfully on both sides on fake numbers. And when that happens, you better win or you're going to be sitting back. I've had plaintiff lawyers tell me to tell the defendants at 11:30 in the morning on a full day mediation, tell them, Volf, if they don't go to whatever $1 zillion we're walking. I'm like, why? We all know you're still at a range that you would take less. Stick around long enough at least to figure out what, for your client's sake, what do they have, or at least as close as we can.
Well, and you've usually
most of the time, by the way, the one case I won't mention who the lawyers were, I told that lawyers when I first started mediating. So I told that plaintiff lawyer, I said, look, number one, I got a bunch of lawyers that flew in from New Orleans to my office. It's 11:30 in the morning. If you tell them, with my ego, even if I was inclined to pay you that number, if you told me to do it, I'm not. I mean, that's how we're all wired, right?
Well, you got Papa Seafood at lunch too. Stick around,
and I got Papa Does Seafood coming. Stick around, but but on that, and then I told this very good plaintiff for. I said, look, stick around. You're going to probably get, with that firm's reputation on a commercial offshore case, you'll probably get paid a little more money than candidly your case is worth. And then the third part was, hey, I just started mediating. It's going to look bad if we ended 11:30. So help a brother out. So we literally at 9:30. That was at 11:30 in the morning. 9:30 at night, the case settled on a multi-7-figure case for probably what realistically on the 19th hole was probably about $250,000 more than the case was worth. But if you'd have left at 11:30 in the morning, you'd have never found that out.
You know, I know we're going to talk Zoom versus in person,
Yes.
but I do want to give Chris a shout out. You know, the big thing is we talked about it's not weak anymore, I don't think, to ask your defense lawyer for a mediation date 6-7 months out. Get it set, have an internal deadline, get with Chris, set it out so you have something to work to. He's that far booked out, but he will work hard to get your case settled. When we've done 2 mediations on a case, he's called me every day this week to talk about getting it resolved and working. So just it's okay to do it. It's not weak to ask for mediation.
Yeah, I actually don't think it's a bad idea. Then we'll answer Zoom, and then we'll go back to drinking. But I don't think it's a bad idea that it's hard in the world we live in to pick up the phone and call people. But I don't think it's a bad idea. Again, 60 days, 90 days out to call the defense. If you're a plaintiff lawyer, who's most of the guys here, call the defense lawyer. Go, hey man, we got mediation coming up with whoever. This is what I've got. We on the same page on economic damages, and just because you'd be surprised. 3 days a week. Sometimes the numbers that are different are insignificant, so it's not going to.
Sometimes the defense is higher. It
Yeah,
happened to me recently.
I mean, what's the harm in making sure you're going to do it? If you're going to try your case, you're going to do it anyways, right?
But be careful what you say because they tell Chris everything.
Yeah, I mean that's a whole nother topic.
Understand excess towers. How can we use excess towers and excess adjusters and lawyers to help us get our cases settled where there's multiple different layers in the pain points you're talking about, and excess lawyers working to get the case settled for not their layer, but the layer below their layer.
Yeah, I mean that's where you got to know the time. I'll let Will can answer that better than me, but I would say that most of these on the cases that are the bigger towers, I've had some where I've had 7 monitoring lawyers in my office in that big conference room at the excess tower. So they each will hire their own little, monitoring lawyer that's not the main trial lawyer. And if you don't know that tower or who they're working for, but Will's dealt. I mean, he would show up in my mediations when he was a defense lawyer and make my life difficult. But yeah.
But they all say you're never going to reach my limits, right?
Yeah, well, I mean that's it is what we make, and I say we as plaintiffs lawyers is what's the tower? Here's my demand, and I wrote a paper for it. Law.com picked it up. It was pretty cool because it was like, no, that's not right. If there's a value in a case, it's fair, reasonable value for the claim, and you can create leverage by having, from a canal standpoint and an equitable subrogation standpoint, having that top attachment point start raining hell down upon people below to settle the case.
What's canal?
Canal is a case that stands for an equitable subrogation concept. Essentially, it's reverse Stowers. If there's an opportunity to settle the case within your layer, you didn't take it, and I get smoked in my excess layer, I can sue you for equitable subro. I can't step in the shoes of the insured on a first-party claim against their own insurer on a negligence standard, but I can, from an equitable subro standpoint, sue your ass for not settling the case that would have kept me clean. His recent one is the Fifth Circuit bike case. That is a very, very good canal case, but not canal.
Objection, that sounds really technical. What's the deal with Omar and the screen jacket? I don't think he won a tournament. And why is Tommy holding the microphone for you?
Yeah, but that's AXA.
So if you're an excess lawyer, the plaintiff's lawyer wants to settle below your
objection!
case.
I want my objection ruled on.
Well, how about the plaintiff's lawyer try to get the case resolved?
I write, and the folks in this room that I've either written them for, team members that have read them when I write them, in my demands, I will actually spell it out. No subtlety. I'm writing at this attachment. Everybody that's in excess above this, you need to implicate your canal opportunities. I picked this number for a reason. We are now friends. Save some money because we go to trial. You're at great risk, and all of a sudden the lawyers get involved and the case gets settled.
Well, you become friends with the defense lawyers at the excess.
The folks, well, and
above
monitoring counsel for the excess tower. Yeah, and there's no doubt that the very good ones that do it, some of your former law partners at your former firm that are skilled at it, they can actually help you when you show credibility. And I think the value's here. It's beneath your attachment. Well, guess what? Let's get this case settled. And they become a bigger advocate than anything you could ever do.
Exactly what Will said.
The critics who say that Thomas John Kirker is just holding a microphone for you and has nothing.
I'm happy to hold his microphone. It's a pleasure to do that.
So tell us a little bit about Zoom versus in person
Yeah.
at the Cannon building.
Yeah, come to the Cannon. By the way, my oldest son's name's Cannon. My building is called the Cannon. And a funny story, I had his friend's football buddy come there and he said, man, Mr. Volf, you own this building? I was like, yeah, not exactly. And then they said, hey, where's your youngest son, Case? And I was like, oh, we don't have his name here.
We got a case of beer in the Cannon building, you know?
Love you, Case.
We got some 40s.
Yeah.
We got some
We
40s.
do have beer. We do have, but all kidding aside, I still like in person, especially on bigger cases. And I would start with on death cases. I would rather mediate every single wrongful death case in person. Both from the plaintiff side to be able to literally and figuratively put my arm around, people who lost. I mean, we sometimes forget the real world side of what we do for a living, but that helps. But on the insurance, when you're doing multiple insurance towers, now granted, not all of them will show up, but enough of them in the tower, plus their monitoring counsel, it's just, we can get more work done in person. Now, half day, personal lines case, probably better stay at your office.
If you want to get away from Jill, just tell her.
Yeah. Sometimes, but I still think I bet I mediate more in person than most mediators in town, just because of the nature of the cases. But I still believe in person mediations. Now, there are benefits to Zoom, even sometimes on the bigger cases, oil and gas, where it's heavy on documents, because I can still share screen. I can myself, okay, you're saying X, but here's Y, or get a depot clip and put it in front of people. So there's still benefits to Zoom. You know what the worst part about Zoom is?
People can mute you.
No. Well, that too. That's pretty hurtful.
Right.
Is that I have
might be a CNN anchor and stand up.
I'm down to 2 jackets that don't have holes in the elbow, because for me doing this, I'm like, next time you mediate with me on Zoom, ask me, show me your elbow. I got Zoom suits now. The right one has 4 of them holes. Yeah.
Professor Volf with the suede patches.
But yeah, full day mediations where you're asking for, a lot of money in person.
Word is you'll drink whiskey with us if you go long enough.
Yeah, I don't know who you heard that from. But,
he lives real close.
All right, everybody. With that, we are out of time.
Can I do one more story?
Yeah, one more story.
I just want to tell why I love Volf and why I met him.
Is this a vodka-induced story? How long?
No, it is. All right.
microphone.
So I met Chris Volf when I first started my new firm, and I had my first big wrongful death case, and I scheduled it for January 11th, with my son being his due date January 17th. Well, my son came January 10th, and we got sent to the hospital. And the first time I met Chris Volf was in a hospital room. And every big moment since then, I've shared with Chris Volf. It was mother-in-law passing away, his dog passing away, my father-in-law passing away. Every big moment has been with Volf. He's always been very kind to my bride, Kristen. He's been very sympathetic. He's talked to her on Zoom videos. It's not just mediation for him. He cares about you. He cares about your client. He cares about your family. So I try to go out of my way to mediate with him. I mediate with him constantly. And so if you can do it, it's just a plug for him. But
Hey, so Omar, how about that feast you made? He's not putting
me? I'm negative.
Yeah.
But he also does a really fun thing where if he gets a mediator's proposal, he does it like
How do you pick those
$592,364. And defense will call you and be like, hey man, did you provide him with some information that gave him? I was like, no, did you? It's like, no. And it gets settled.
Well, try to Stowerize the remaining excess layer once he sends a proposal down to the penny. Can't do it.
Yeah, it's fun. Mediating with Volf is fun. Again, he'll wear your ass down. Don't tell him any personal things. He'll use it against you.
That's not true.
You get a verdict for $85,000. He'll tell you that, hey, they only brought $85,000 to this mediation.
I did do that.
Well, yeah, he just called me out of the blue. He's like, hey, they only brought $85,000 to this mediation. I was like, well, that was a real asshole move, So enjoy it.
They actually brought less.
You got interest? You got interest?
Pre-judgment interest and court costs were not
You're gonna have
considered
like
in that.
$92,000.
At least 100. At least 6
all
figures.
Saudi's fault. All Saudi's fault.
All right. Well, thank you everybody for coming. We're going to stick around and drink for a little bit, but you can go or you can hang out with us. But I really appreciate it.
All right. Thanks, buddy.
Thank you.